although I'm sure everyone would like to see it in person. So
we're now streaming live on Facebook, which is lovely. Let's give it a couple more minutes and see if we get a couple more people to come in. This is good. We have 15. We had 17 signed up. We're doing well.
Yeah, I guess it wasn't that nice of a day, so.
See, we picked a good day for it.
Yeah.
Okay, we're going to go ahead and start because I know that you're on a time crunch as well. But my name is Penny. I'm from Harrow Library. Thank you all for coming. So we are talking about wills and trusts with Jake. I know I'll say your last name wrong, so I'm going to let you do that.
It's Ehrensaft.
Thank you, Ehrensaft. I will probably butcher it. I did try to, if you have registered on our website, I did send out handouts this morning to your emails that you had registered with. So if for some reason you are joining us and had not registered and would like the handout, or the email bounced or something weird happened, because who knows, you just never know, you can let us know at the library and we will get a copy of the handout if you need one. Meanwhile, we are in a webinar function, so you're only really going to see Jacob and his slideshow. And if you have questions, if you could put them in the Q&A, or you can type things in the chat as well if you'd like, but the questions in the Q&A would work better, and we will take those, Jacob, at the end. Would you prefer?
Yeah, I usually answer the questions at the end, and I usually ask that people ask them towards the end, because by the time we get there, I may have already answered those majority of questions by the time we reach the end of today's program.
Okay, so I think we're holding pretty steady at the number of participants. So Jacob, I think it's all yours. Go for it.
Okay, thank you, Penny. Do I need to be spotlighted or something?
It looks like from where I'm sitting, you are the only thing on the screen except your slideshow. So I think you're good. Okay,
excellent. Thank you. Okay, so welcome everyone today to today's Wills and Trust program. Program itself will last about an hour and 10 minutes, and then I'll open it up for questions and answers. As Penny said, you need to put those in Q&A or the chat function. Also, today's program, what else would you expect from a lawyer but a disclaimer? Today's program is for informational and educational purposes only. Nothing in this program is or should be considered legal advice. If you do need legal advice, you should consult an attorney in his or her office. Also, none of the information that you see today can be retransmitted or reproduced without my express written consent. So, without further ado, I will begin today's program. Now, I realize today's program is wills, trusts, and estate planning basics. But before I can really talk about wills and trusts, I generally need to speak about what most people are coming to me to avoid, and this is what we refer to as probate. So what is probate? Well, probate is the court process for distributing a deceased person's estate. It's not to say that there's any litigation or that that litigation is involved, even though there could be. However, in the state of Illinois, as well as most of the states, although this program is for the state of Illinois, the probate procedure is going to be required if you die with any real estate in your own name, and or if you have $100,000 or more in total without listed beneficiaries who survive you that's not in a trust, etc. And why would you want to avoid probate? Well, probate does not need to be avoided at all costs. I generally think it should be. It's not the end of the world. I know a lot of people have heard that, well, that means the state takes all of your money. That's not the case, although sometimes it does feel like it. But the point for probate is it exists so that if you have not properly planned ahead, your appropriate creditors get notice. They have to be notified that you've passed away and have the right to make a claim. Just because you have died does not mean your debts are extinguished. and B, to let your heirs or legatees know that you've died. Basically, the beneficiaries of your estate, they have to know that you've passed away and also have the right to make a claim. Now, why do you want to avoid probate? Well, it's usually the time and the expense. Probate takes a minimum of 6 months from the time the estate is opened by the court until it can be closed, because that's the time period where creditors can make claims. Also, the expense, I'd say the expense of going through probate is about 3 to 5 times the cost that it would be to avoid probate. And usually I wouldn't say most probate estates are closed in 6 months. It's usually about a year or a year and a half. It might take some time to sell the real estate, pay the taxes, get some money, etc. It's not to say that even while most of them are closed within a year or a year and a half, if there's litigation, businesses hard to sell assets, or if you have an executor who is moving rather slowly, it can take quite a bit longer. Now, I always like to tell people, don't wait until it's too late. That'll be the theme of today's program. But if you know somebody who has recently passed away, they really need to get started as far as usually hiring an attorney to open the probate estate. And the reason is at the moment, this is during COVID, it takes a lot longer sometimes to get things done, to get the information out to people, for the court to actually issue the papers once the estate has been opened, etc. Also, during the last few years, I've been working with one of my colleagues on some wrongful death lawsuits. And for those, it's really important, even if you're not sure if you should go forward, if a loved one is either disabled or deceased and it's due to a personal injury, wrongful death, or medical malpractice claim, that's something you really need to do immediately, because for that, there is a statute of limitations. There's a specific time period where you need to bring that case, otherwise you're barred. And we've had a few cases where everything has gone, obviously as well as they could and with decent settlements, but I've also had one poor lady who called me and it was too long, even though her spouse was killed in an accident. They didn't bring suit until too long, and then she had absolutely no claim. So realistically, for this, or honestly any other type of law, really don't wait until it's too long. You need to act quickly. Waiting is never in anyone's best interest. So let me go on to something that probably most of you are less familiar with, if you are even familiar with probate. And when I said probate, I meant probate for decedents' estates, or probate for people who are deceased. Guardianship, this is specifically guardianship for disabled adults. And most people really don't think about disability, or if they do, perhaps they've thought that, oh, well, perhaps if I'm disabled, my spouse could make these decisions for me, or maybe my adult child could make them for me, or maybe I could make decisions for my adult child who's living at home, going to school, working, etc., right? Well, unfortunately, too many people find out this is not the case. Guardianship is the court process for appointing an individual who is referred to as the guardian to make decisions on behalf of somebody else. And those decisions could be just healthcare decisions, they could be financial decisions, or potentially both. And guardianship, unlike probate, does not have a definitive end until somebody dies. So unlike probate, which I said on average is anywhere from about a year to a year and a half in most cases, guardianship lasts from the time somebody becomes permanently disabled until their death, with annual court costs, attorney fees, accountings, etc. And if you want to make any major decision like sell a house, move that person who is disabled out of state, you're going to have to get court permission for all of these major decisions that are not routine. In addition to that, guardianship is much more intrusive, and let me explain what I mean by this. So many years ago, it was not that difficult to get your spouse or family member committed, but obviously the courts saw that it wasn't such a great idea, that the person who was allegedly disabled had no rights. And because of that, there is a process in place. So generally what happens is somebody says, well, I think my friend, family member, really needs some help. He or she can't manage his or her own healthcare and or financial decisions. They need to get a note from a doctor that says this person is disabled and to what degree they're disabled. I'm talking about incapable of making healthcare financial decisions, not a physical disability necessarily. And then based on that, the court is going to have the sheriff serve the person who is allegedly disabled, let them know that there's a court date, let them know that somebody has said that they are, somebody thinks they're incapable of making their decisions, let them know they have a right to have an attorney, etc. The court then sends out their own attorney, not somebody who represents the person applying to be the guardian or the disabled person. This person represents the court, and that's a GAL or a guardian ad litem. The purpose for that person is to evaluate the person who is allegedly disabled from a legal standpoint to see if he or she can actually make legal decisions from a legal perspective as opposed from a medical perspective. And it doesn't matter how little that impairment may be or how great it may be if that person doesn't talk or won't speak to anyone, etc. This is a process that needs to occur. And it's usually very difficult for the person who is disabled if he or she knows what's going on. That's obviously not a lot of fun. For the friends and family, if they're not agreeing, that can be very difficult for them. They may disagree where the person who is disabled should live. Should they live at home with a caregiver, at assisted living or nursing home, or some other type of living arrangement? And also the money. How should the money be spent, invested, etc.? So it's not a lot of fun for the disabled person. It's not a lot of fun for the family and friends. The only person it's great for is somebody like me standing in front of you, because attorneys are going to get paid hourly for how long ever this takes, from oftentimes many years until the person passes away. It's very rare that somebody needs a guardian and then later on doesn't. It's probably less than 1% of the cases. I've dealt with it before, but usually when somebody is disabled, that's usually a permanent case until their death. So if you don't get anything else out of today's program, you really do want to avoid guardianship at all costs. And I'll explain how to do that soon. Now, I like to call this program Wills, Trusts, and Estate Planning Basics. I find out when I call the program just estate planning, it can be very intimidating for a lot of people. You might say, hey, I don't have millions and millions of dollars. Do I really need an estate plan? Well, yes, I've done estates for people that have $2,000. I've done it for people who have had $20 million, and a gamut of people in between, just depending on what they needed. But really for today's program, an estate just means everything that you own. If you've got $1, you've got an estate. There might even be some estate planning you should do if you had no money whatsoever. Now, estate planning is not just about who will get your stuff when you die, your money, your house, etc. That's definitely part of it, but that's not the only thing. Estate planning is a process where individuals can determine who will act on their behalf if they become disabled, who will make their healthcare decisions, their financial decisions. If you have minor children, who will care for them? Where will they live? Where will they go to school? Who will manage the money until they're adults? And also, who will receive your property when you die? Are there some people who won't receive property? Is it somebody who's going to receive all of your property? And will the recipients of your property receive all of the money at once? Will they receive it over time? Are there some people that you want to make sure will not receive any property who normally would if you did not plan ahead? So these are all components of estate planning. And today I'm going over the basic components of estate planning. There are other documents definitely that could potentially be used, but these are the forms that apply to the majority of people. And these forms are wills, trusts, powers of attorney for healthcare, powers of attorney for property, and living wills. I'll go through them with what I think is the easiest and move my way down to what I think is most complex with a few examples along the way. So the first thing I'll discuss today is a living will. Now, a living will doesn't have anything to deal with your assets. This is really a healthcare form. I get a lot of calls and people say, I think I need a living will. As you'll see probably later on, they usually mean a living trust, but a living will may also be necessary. It just depends. This is a document in which a person refuses medical treatment if he or she is suffering from a terminal illness. So these were in the news a number of years ago, if anyone can remember a young lady named Terri Schiavo. And she was in her 30s or early 40s, probably never thought about dying, let alone becoming disabled. But for close to a decade, she was on artificial feeding, hydration, or respirator because she was in a coma. And through this decade or so, her parents were arguing through the court system that she should be kept on life support, and her husband was arguing that she should be taken off life support. However, what she really wanted, we'll never really know because she never reduced it to a legal format. Um, and at the end of the day, she was eventually taken off life support. But if she would have had a living will, it was argued that, all of this time and energy and money, attorney fees, all the grief spent by the family could have been avoided if she would have thought about it and would have put it in a correct legal document. So that's all I'll say about a living will. Do I think a living will is necessary for everyone? No, it reflects your own personal wishes. If this is something that you'd say, hey, I think I really would like this, of course. If it's something you don't want, that's fine too. Most of my clients, I generally prepare the form, let them read it. And if they want to sign it, great. If not, that's fine too. Sometimes even for spouses, sometimes one spouse wants it and one spouse does not. So it's a personal choice for really the living will. But the one form, and this is related, but definitely not by any means the same form, is the power of attorney for healthcare. And in this form, you can appoint somebody to make medical decisions on your behalf, and this prevents guardianship, at least with regards to healthcare decisions. Now in Illinois, for this form, it is one person at a time, but as many people in succession as you'd like. So you can say my first choice is my spouse, my second choice is my child, my third choice is my friend. It can be anyone that you would like, except for it cannot be me because I generally will not do it, with the exception of my parents and my wife. And while it can be a doctor, it cannot be your doctor because there is a conflict of interest. So really make sure you choose the right person for the job. Don't arbitrarily say my spouse because that person is married to you. You should state whether, whether this person is the right person, whether that person can move quickly, if that person is emotionally capable of perhaps taking you off life support, etc. Now, I usually tell people, all things being considered equal, somebody who lives closer, not necessarily by miles, but out of state versus in state or out of the country, closer is generally better. However, if somebody out of state has medical knowledge, is more level-headed, is more decisive, that may be the better person for the job. Especially with things like Zoom, you don't necessarily have to be there all the time. Also, make sure that person has enough time to devote to making these decisions, because the power of attorney for healthcare may make very minor decisions, or perhaps none at all. Maybe it never needs to be used, or they may need to make decisions for you every other day because your medical condition is drastically changing, and this can go on for a while. So really make sure that person has enough time to devote and can do the job for you. The next form is the power of attorney for property. Now, this is not power of attorney for real estate. This is what the state of Illinois calls the power of attorney for finances. And in this form, you can appoint somebody to make financial decisions on your behalf, and this prevents guardianship. When you're choosing this person, make sure that person is A, honest, and B, also decent with money. You don't want to choose that person that you think is a really nice guy or lady, unbeknownst to you that they've filed bankruptcy or that they have health care or health needs, that could be very serious. Because I've had this happen, and somebody sometimes uses, these forms for their own purposes. Legally, they're not allowed to, but I always tell people, if they still have the money, you can soon get the money back. But if they've spent it and they don't have anything left, very hard to get, obviously, blood from a stone. So power of attorney for property, very important. Make sure you're choosing somebody who is the right choice. If you have a form that says the power of attorney for healthcare and property, and that's a joint form, you do not have the right form for the state of Illinois. Now, a lot of times people will do these forms and you put them away for 10, 20, 30 years. The attorney you met or used to draft them may have said, for example, hey, if anything changes, call me. And you may not have ever heard from him or her again. I like to call my clients every 2 or 3 years and say, hey, has anything changed with you? And by the way, if there's a change in the law, I might like to let you know. And some people will say, well, nothing's changed with me. I've done this, no addresses have changed. The people are still the right people to make decisions for me, etc. Well, I'll tell you, even if you haven't had any changes yourself, the law may have changed. Because if your powers of attorney for healthcare and or property are older than July 1st of 2011, they probably don't comply with the current law. Now, there were a number of major changes. The first one is revoking prior powers of attorney. What does this mean? Well, if you did a power of attorney for property in 1990 and you did another one in 2000, you'd presume the one in 2000 was the only one that's good, right? Well, not necessarily. It could be argued they're both still good. The more updated form of the power of attorney for property revokes all prior powers of attorney, saying the newest one you signed is the one that's good. There's also a cover page for the power of attorney for property. It's a little more convoluted than I think it should be, but at the same point, it gives you some idea of what this form does. It says in this form, you're appointing somebody to make financial decisions on your behalf. You don't have to sign this form if you don't want to. Of course, if you do not, it's not effective. And if you have questions regarding this form, you should ask an attorney to explain it to you. Perhaps more importantly, though, the power of attorney for healthcare. Compliance with HIPAA, or the Health Insurance Portability and Accountability Act of 1996. So what is that? Well, HIPAA is federal privacy law. Used to be when you went to the doctor, they handed you some paper. They'd say, under federal law, we cannot release any of your information without your prior written consent. These days, you see a tiny screen. You click to say, I've read this. No one does. And it says something of the same note. Now, it's not to say an old power of attorney for healthcare is useless. No, the person that you've appointed to make decisions for you still could. But under federal law, your healthcare provider, your doctor, your nursing home, hospital, etc., cannot legally release any information to the person who's supposed to be making decisions for you. Now, back in the day, a number of attorneys might have drafted a separate HIPAA disclosure. That is not necessary in the state if you are using the correct up-to-date forms. And some people will say that, for example, well, I did mine after July 1st of 2011. I'm fine, right? Well, maybe not, because the power of attorney for healthcare was updated yet again January 1st of 2015. Now, this is rare. In the last 2 years, there have been a number of updates, but prior to 2011, the power of attorneys in the state of Illinois were not updated for more than 20 years. The new form was created because a lot of attorneys felt that the old form was just a little too difficult for somebody to read. Oftentimes, somebody may be very sick in a hospital, a nursing home, etc. The new form is much simpler and efficient. It's about 6 pages or so. It is written actually in English, not in legalese. So if you take the time to read it, you should be able to understand it. And it also asks a number of good questions, such as, what do I want my agent to know? What decisions can my agent make? Who should I choose as my agent? What do I do with this form? And what happens if my agent doesn't act? And this will also be a good point to tell you not all attorneys are created equally. I generally tell people the best thing that you can do for your estate and your beneficiaries would be to hire an attorney who does estate planning and does that as his or her primary area of business. Because then it should be a very efficient and effective plan that carries out your wishes. If you decide to do nothing at all, probate and guardianship has been around for a long time. It will continue to be around for a long time. But the worst thing people generally can do is to try to do it themselves, or to do it with an attorney who really doesn't focus on this area of law, because it will take you a lot more time and a lot more money to try to correct something that's been done poorly oftentimes than if you did nothing whatsoever. I've had a number of years where 20, 30% of my income in a given year is trying to undo the mess that somebody else did and did incorrectly, which will make it a very bumpy ride for most of the time. Also, this is another good time for an illustration. So a number of years ago, I knew an attorney, very smart guy, and I asked him if he would be a signer or a witness for one of my will signings and powers of attorney. A few hours later, he called me and said, Jacob, I hadn't seen those powers of attorney for healthcare and property. Would you mind giving me a copy? And I said, sure, there's another attorney I know. I'll be happy to give you a copy of my forms. At the same point, that meant for the last 8 or 9 years, he had been giving his clients forms that did not comply with the current law. And it's not to say that this guy wasn't a great lawyer. He was a very smart guy, but you can't keep up on every area of law. He did a little bit of probate, a little bit of guardianship, a little bit of divorce, a little bit of bankruptcy, real estate closings, criminal law, et cetera, et cetera, et cetera. Estate planning is an area you really need to keep up on. Not that the other areas of law I'm saying that you shouldn't, but this is one that you really need to be up to date on the laws and what the changes are. This is also where I will put another example for don't wait until it's too late. A number of years ago, I had some clients who came to me, relatively simple estate plan, wills and powers of attorneys. And I called and said, okay, well, I've got your forms done. When do you want to come in and have them signed? And the husband said, well, we'd like to come in about 4 weeks. And I said, why do you want to wait 4 weeks? Your forms are done. You've already paid me. And he said, well, we've got a few things to do before then. And by the way, next week, my wife is going in for some minor surgery. And I said, minor surgery? And he said, no, don't worry, Jacob. It's not a problem. You know, it's just outpatient procedure. I still repeated, I think you really should come in. And he said, well, thanks for your advice, but we'll see in 4 weeks. 4 weeks later, I got a call, but not really the call that I wanted. He said, well, my wife was at home doing fine, but there were some issues. She had to go back, had a number of other surgeries, and now she's in a coma. The doctors are asking for her power of attorney for healthcare so I can make her healthcare decisions. And by the way, all of her money is in a 401k, and I can't get to that to pay her bills. But you already have those powers of attorney in place. Can't we use them? Well, fortunately, I get this question all the time. No, you can't do a power of attorney and sign it after somebody is disabled. You need to do this beforehand. So even though we had the forms ready to go, they were not signed, completely ineffective, had to go into court, get a guardian appointed. After a couple of years, she passed away with about $150,000 in her 401k. And fortunately, on that 401k, she had listed beneficiaries. Unfortunately, they were not updated beneficiaries. They listed her parents who were deceased. So we had to go into court yet again for probate for the decedent's estate because she had died with $100,000 or more without beneficiaries who survived her. So it's not enough to start the estate planning process. Yes, you definitely need to, but you also have to finish it and try to finish it within a reasonable amount of time. Now we'll go to something that most of you are probably a little bit more familiar with, and this is a simple will. So there are good and bad things about doing a simple will. Usually a simple will is the absolute minimum, but for a lot of people, it may not be as good as doing a will and a trust. It just depends on what your wishes are and what your assets are and who your beneficiaries are. Now, simple wills, there are a number of benefits, but simple wills, well, what do? Well, they give beneficiaries assets outright. It means it's not withheld. It just says I die, and when the probate estate is concluded, the assets go outright to these individuals. They get everything at once. Simple wills do go through probate generally. If you're married and you've listed your spouse jointly on everything, or your spouse is a beneficiary on all of your assets, it may not need to go through probate, but then usually when both spouses die, if there's only a simple will, it's generally going to need to go through probate. And if it does go through probate, information is available to the public. I'll explain shortly while the last one is important. So people will ask me, well, if that's going to be the case, why do I even want to do a will? Well, there's still a number of benefits to doing a will. First one is you get to choose your executor. The executor is the person that when you die is going to be responsible for hiring the attorney to take the estate through probate. They're going to be responsible for gathering your assets, for paying off any rightful beneficiaries, for making sure all the administrative tasks are completed, like paying final tax returns, and then distributing the money to the rightful beneficiaries. You can also choose, obviously, who the correct beneficiaries are going to be. And that can be very important, and I can give another good illustration. I usually tell people, if you don't have a plan in place, the state where you live has a plan in place for you. And for Illinois, it's the Illinois Probate Act. And at least the first few aspects of it I'll share. And that usually says, well, if you're married and you don't have any children, everything goes to your spouse if you die. If you're not married but you have children, everything goes to the kids. But if you are married and you have kids, half goes to your spouse plus an allotted amount, which is usually about $20,000. And
I'm sorry, it looked like Jacob froze. Let me give him a quick call and let him know he may need to reset his computer. So hold on 1 minute. Let me call him and I'll let you know what's going
sure, I'll
on.
sign over
Oh, there
my
he goes.
interest. In the
Yeah, you froze for a minute there, Jacob, just so you
okay.
know.
Okay,
So
some internet
we may
issue.
have missed something there for a second.
Okay, let me go back. I was just saying, in the example, there's a husband and wife. The husband owns the real estate in his own name, but he passed away and the wife's name was not on the deed. And the way it works is, if they have children, about $20,000 usually goes to the spouse, and then the rest is split 50-50. One son said that half of the interest in the house, well, the interest that I received, that 25%, sure, I'll sign it over to my mother. But the other son had a different idea, saying that if I realize if I don't get my inheritance now, I'm probably never going to get it. So he said, I want my 1/4 interest in the house. And of course, no one wants a 1/4 interest in a house. He forced the home to be sold. He got his 1/4 interest in the house. And then the mother and brother never spoke to him again. But this is something that does happen from time to time. And that's why I tell people will is a minimum. I've even had people who have had very little to no money, and sometimes this comes into play. So sometimes what happens is, well, maybe there's a wrongful death case, like I was alluding to before. Well, if you haven't planned ahead and had a will, even though you thought, hey, I really don't have a lot of money or anything, well, I've had clients leave millions of dollars to their loved ones, or at least their family member, unbeknownst to them, pursuant to a lawsuit, even though they may have died, initially penniless. And where will this money go? Well, if you have 2 kids and one lived with you and took care of you, and one you haven't seen in 20 years, if it's a wrongful death case, chances are they're both going to get about an equal sum of money. Same thing for a spouse you haven't seen for a long time, etc. Or what if you wanted everything to go to your spouse? What if you had minor kids, etc., etc.? So, as I said, a simple will is a bare minimum, along with obviously powers of attorney for healthcare and financial decisions. I did have one client who became severely disabled in a bus accident. She became a quadriplegic, but because she had a power of attorney for healthcare and property in place, at least while she was still alive, it allowed her daughter to immediately begin the lawsuit, so that evidence could be preserved and that they would have the maximum settlement that they could get. So simple wills are still very important. It may not be the only thing that you need, but at very least, it's something that you should have. Now, the other type of will I'll speak about today is what is referred to as a pour-over will. It's like a pitcher pouring over into a glass. And you can always have a will without a trust. If you have a simple will, that means that's your main document. A simple will might say, for example, if I die, everything goes to my wife, but if my wife doesn't outlive me, everything goes equally to my children. A pour-over will, they're usually drafted with trusts. The only major difference is the part of a will usually says who will get the personal property, jewelry, furniture, cars. And then it says, I leave all the rest of my assets to my trust. And then my trust will say, for example, everything goes to my wife, but if not equally to my children. A part of a will, if you have a trust, that's going to be a supporting document to your trust. It's meant there is a safety net for anything you did not properly transfer to your trust. So really something you should always, you could have a will without having a trust, but you should never have a trust without having a will. But the only major difference is a will is the main document, part of a will is just a supporting document. And on to what I think
Okay, he froze again, guys. Obviously, you know that. Give us a couple of minutes or a few seconds and see if we get him back. He must have a weak internet connection or something. I will call.
component of your estate.
There he is. Jacob, you froze one more time.
Sorry about that. I'm not quite sure what was happening with my connection.
Okay, now we see you big, but share your screen again, please.
Sure. Let's see. I'm trying to, here we go.
Got it? Excellent.
Yes,
Okay.
Okay, I guess I need to advance a little.
Okay. That's okay. You know, everybody's getting very used to these weird glitches with Zoom, so.
Yes, yes. Well, hopefully in the fall or April or whenever I'm back for you, maybe we can do a in-person one. We'll have
A real
to see what the health
person.
condition is. Yes, yes, yes. And I'm sure everyone would like to see people in person. at some point,
I'm pretty sure about that too. Okay, I think you're set.
Okay, so living revocable trust. So as I pointed out, this is its purpose is usually to avoid probate and guardianship if it's used correctly. And it gets its name. A living trust, you're supposed to put your assets in it while you're still alive, the majority of your assets with certain exceptions. And it's called a revocable trust because you can always change or terminate it. And as I said, this is a component of most people's plans if you want to avoid probate and guardianship for the majority of people. Now, some people on TV I've watched, they say everyone should have a living revocable trust. Is that true? Not necessarily. It really depends on what your wishes are. Some people will say, well, you know, my kids, my friends, family, charities, they're going to get a windfall. If they have to spend more time and more money to do it, I'm fine with that. I can just use a simple will. That's your feeling, that's completely fine. But a lot of my clients, even ones who are giving everything to charity, would prefer it goes in the most simple and efficient manner. And that's easiest for everyone and is more cost effective. So what do living revocable trusts do? Why do you have them? Every now and then I get something, sometimes even from another attorney, and somebody says, well, I was told, you know, if I don't have, you know, $5 million or a few $1 million, I don't really need a trust. That's not the case. Money is not the only reason you have a trust, and you should still try to avoid probate. I'll also point out you should at least speak to an attorney before making any decisions. Some bankers will tell you, well, you don't have any real estate, or aside from your real estate, you can just, you know, put everyone on as a beneficiary on your bank account or your financial account. Yeah, that's true, but that comes with a lot of problems. Not to say that that can't be a component of your estate planning, but if it's the only one, most of the time, that's a very poor plan. The reason for that is oftentimes what happens is, well, let's say you have 2 children. Well, and each of your 2 children, you have a son and a daughter, they each have kids of their own. Well, one of the 2 of them die. It may wind up going solely to the one who survived, leaving out the deceased person's children. The other one is that if you do it that way, as opposed to it going through a will and a probate estate or through a living revocable trust, creditors, as I mentioned before, don't go away. So let's say you have $50,000 or more in bills when you die. Let's say you have $80,000 in bills. and you listed named beneficiaries. Well, each of your two kids gets $100,000 because you died with $200,000. One of them spends all the money, and a very angry bill collector is looking around and discovers the other one still has $100,000. Well, they'll take the $80,000 for the person who kept the money and leave them with $20,000. Not really a fair distribution. Whereas if it went through a will and a trust, $80,000 is paid first, and then they each get their $60,000. So there is not that issue. There are a lot of other things that living revocable trust can do, but for people that think just listing beneficiaries is a sufficient estate plan, the vast majority of time it is not. So living revocable trust, if you use them correctly, they can be used to avoid probate and guardianship. And why does this work? I'll get to the next 2 points in a minute. Well, I usually tell people, at least in this respect, think of a living revocable trust like a corporation. Corporation can own things, can own bank accounts, can own real estate, can own personal property like furniture, etc. And the person that controls the corporation, at least the smaller one, is usually the president. But if the president dies or becomes disabled, there's a vice president that steps into his or her shoes and continues to run it. Revocable living trust works in the same way, or living revocable trust. Technically, it owns your assets. Now, it doesn't mean you can't spend your money. You can still sell your house. You can still spend all of your money, go to Vegas, blow it tonight, or you can keep every penny of it. You can still use it exactly the same way. But in order for it to be effective, for example, if my house says the owner is Jacob Ehrensaft, when I do a living revocable trust, there should be a new deed that says the house is owned by the Jacob Ehrensaft Trust. I can still sell it. I can still take a line of credit out against it, etc. None of that is hindered. But that's a step that needs to be done, because just having a living revocable trust is insufficient. You still have to use it correctly. And if you avoid probate, this can keep the information private. I said I'd get back to it, and this is the point where I will. So if you have assets that wind up going through probate, this is public knowledge. There's a publication that says how much money there was in the estate and who the beneficiaries of that estate were. And that can be very problematic. And let me give one good example of what can happen. So a few years back, I got a call from a very distressed family. What happened was that there was an issue with their mother. Several years prior, the husband only had a will, but he had a lot of assets he didn't list his wife's name on as a beneficiary. They all went through the will and probate to her, but it was public knowledge. And after he died, after a year or two, the wife felt that she should move on with her life. And she met a very nice, sophisticated, handsome gentleman. And after they had been dating for about 6 months, he gave her a very nice, sophisticated business proposition. One that didn't require just some of her money, one that required all of it. And of course, her kids said, no, mom, what are you doing? What do you know about this guy? Don't do it. And she said probably what we'd say to our kids, or what most of our parents would say to us, which is, I'm your mother. Thank you very much. I think I can make my own decisions for myself. And sure enough, she did. She gave him the loan he was asking for. And then she found out he was truly, madly, and deeply in love. Not with her, but with her money. We don't know who he is. We don't know where he is. And a lot of people will say, well, you know, that lady couldn't have been very smart. I would never do something that stupid. Why are you giving me this example? Well, as we get older, we fall a little bit more prey to undue influence. We might be influenced to do things that we would not have done when perhaps we were younger. That happens all the time. I'm sure there are a few people in this room that have gotten phone calls, you know, throughout the years that have said, you know, if you don't pay this debt, you're going to be sued. You owe the IRS X amount of money. You need to extend your auto warranty, whatever it is. There are a lot of these calls, but a lot of them, particularly seniors, do prey, you know, are easy prey for these people who are trying to take advantage. And oftentimes, when there is a relationship, whether you're married or unmarried, opposite sex or same sex, usually in a relationship, there's also one person who controls everything. And just to go back from that, on the undue influence aspect, I'll usually tell people, I don't know if anyone in this audience has ever had a relationship that did not work out. I assume there have been one or two, but that you didn't perhaps date the wrong person, fall in love with the wrong person, marry the wrong person, etc. So these are all things that you should keep in mind. But back to the relationship. So if you're in a relationship, oftentimes one person is in charge of the money. They might be responsible for paying the bills, making the investments, etc. Unfortunately, that's almost always the person who dies first. Now, anyone watching it with your significant other today may be saying, thanks, honey, I'm pretty sure that's going to be you. But all fun and games aside, you may be leaving somebody not only with the grief of your passing, but also with a huge financial responsibility that he or she will be completely unprepared for. And I've had it over the years. I've had a few people who have been mature enough to say, I really need some help. How can I get it? Okay, that's fine. And there are a number of places that can help you manage those funds. But most people generally don't ask for help or realize they need it. And if you had planned ahead, this would not be necessary, because that's the fourth bullet point. You can give income to a beneficiary without giving them control. You can say, basically, I have a trust, all of the money in there is to be spent on my spouse for his or her benefit, or my partner, whatever it may be. And that money can be used, but not necessarily controlled, and that'll prevent somebody from getting a lump sum of money that they can blow very quickly, because the money can sometimes be gone when somebody doesn't know how to use it properly. Also, friends, family members can sometimes take advantage of somebody who is in a more vulnerable state. So that's something to really think about. Also, giving income to a beneficiary without giving them control. But what if one of your other beneficiaries is in a similar situation? Some people have told me, look, my child is 50, 60 years old. He or she never has been good with money. He or she never will be good with money. That's the case. I want to make sure that they have a place to live, though. So you could have it where they get a stream of income with a separate trustee who's got discretion to make payments, etc. What if the person you want to leave money to has a substance abuse problem, drugs, alcohol, etc.? Or what if they have a gambling addiction? You want to make sure that they maybe never receive money directly. Maybe somebody buys their food for them. Maybe they only give them a certain amount of money that can be used, paid directly to have a place to live for an apartment or something of that nature. Also, what if you have minor children? Well, you can't legally give money to minor kids. They have to have guardians appointed. And then when they're 18 or 21, depending how things are set up, they may receive everything. Now, most of us can remember when we were young adults. If you had to receive $20,000, $20 million, or whatever the sum may be, would your first thought be that I'm going to use this money to pay for my education and then prudently invest it for my retirement? Probably not. We don't make the best decisions when we're young adults. So for that reason, most people will generally say, for example, when I die, maybe a third of my money goes to my kids when they're 25, a third goes to when they're 30, a third goes when they're 35. Could be different ages, could be half when they're 25, half when they're 30, whatever you think. But that way they don't get a lump sum of money and blow it all. And you can have somebody who manages the money for them, can still provide for their education, a place for them to live, et cetera, et cetera. Also, what if you want to give money to somebody who's on Medicaid? Assuming they're at least under 65 or significantly under 65, you can do a special needs trust. Because if you give somebody money and they're on Medicaid, you may completely discontinue their benefits. That happens all the time. They have to burn through the money, and when the money is gone, they have to reapply for Medicaid. Now, a special needs trust can be used where you leave money to individuals, but it's for their benefit. It's meant to supplement but not supplant Medicaid. And this is very important. Now, it is restrictive. It's not to say that that person has control of it. They absolutely cannot. And it's not to say that they can use it for anything. It is restricted on what it can be used for. But oftentimes it's used to improve that person's life, maybe allow them to go on field trips, movies, vacations, etc. And if there's any money left, it doesn't go back to pay the government. This can be used generally to, let's say, give to your other children, or I had one client who said, it'll go to the facility where my brother lives, because a lot of times homes or nursing care facilities, they have a set amount of Medicaid beds, and anyone else needs to go into private pay. Well, this would pay for people in that circumstance who couldn't get into Medicaid, so they had a good place to live. And when the money ran out, they could be kept on Medicaid. So really a great way to plan ahead for people. This will also be where I give, don't wait until it's too late one more time. And so a number of years ago, I was dealing with one of my clients. He was finishing up with his brother's probate estate. And I said, look, you saw how long this took. You saw how expensive this was. And especially in your case, because you're not married to your significant other, wouldn't you want to make sure that she receives her money quickly and easily? And he said, yeah, I think that'd be a great idea. But every year we generally go out of state when it's winter. We're leaving in a couple of weeks. I guess if I don't do anything, I'll just have to live until I get back. Now, those were his exact words. I could not make this stuff up. But no, shame for anyone who thought he died on that vacation. He didn't. But about 4 months later, I did get a call from him, and he said, Jacob, I thought I called you a few weeks ago. I guess I didn't, but I was having a few issues. I had a stomach ache, went to the doctor. They removed a tumor from my stomach the size of an orange. By the way, could you do a will and a trust and powers of attorney and send them to me with instructions? I said, sure, I can do it. Not my preferred method. But at the same point, I sent it to him. He signed it. I transferred his house into the trust. And when he came back to Chicago, I asked him, well, did you do everything I told you? Did you put, I know you have one bank account that had a couple $100,000. Did you put that in your trust? And he said, yeah, I listened to you. Fortunately, 6 months later, he died, and he did not listen to me. He decided he would listen to his girlfriend, because why would you want to listen to your attorney when what you read on the internet, see on the news, hear from your friends is going to be so much better advice, or from your bankers? And his girlfriend said, well, I heard if you put somebody's name on the asset, it doesn't need to go through probate. But in case something happens to me, especially since you don't have any family that you know of, couldn't you list my adult son and my 2 minor grandkids? So that's what he did. So when he died, that $200,000 account, $50,000 went to the girlfriend, $50,000 went to her adult son, $50,000 went to each of the 2 minor grandkids who won't be able to touch it until they're 18, and then they'll get all of it. And if somebody needs to use it before they're 18, they'll need to go into court and get a guardianship estate open for them until they're 18. Not what he had planned, but you still have to listen to your lawyer. That's the other thing. Also, another thing, a lot of times people will tell me, well, Jacob, the reason I really avoided doing my estate planning, my will, my trust, my powers of attorney, I don't really have somebody that I trust to make these decisions for me, to make my healthcare decisions, to make my financial decisions while I'm alive or when I'm deceased. Well, that's not a good reason not to do estate planning. If you don't put anything in place, either a friend or a family member may need to come forward and the court may appoint them, or you might get a public guardian who really is not going to have enough time to devote to your individual circumstances. There are banks and financial institutions that you can pay to do this, and there are people such as sometimes social workers who you can pay to have as your power of attorney for healthcare. Yes, you'll have to pay them, but on the bright side, they don't have a conflict of interest. They're not trying to do anything to generally take your money, aside from obviously getting paid the fee that they'll receive. They'll do everything and do it the way that you have told them, and they're not going to have the same emotion that perhaps a friend or a family member may have. So that, not to say that everyone should use a third party, but I tell people that's always an option and something that everyone should consider, because even if you think all of your kids or your friends or family members get along, I always tell people, sometimes think of your estate like a nice big juicy steak, and when you die, everyone has a fork and no one has a knife. Not the nicest way to think about it, but rather be skeptical and have all of your wishes fulfilled than to, be too optimistic and have things go wrong, because sometimes they do. And you need to be honest about how everyone in your family and the dynamics, how they get along, etc. So Now, also, as I was telling people, you need to make sure your plan is updated. There was a huge overhaul to the Illinois Trust Law, January 1st of 2020, called the Illinois Trust Code. It used to be called the Illinois Trust and Trustees Act, and there were a lot of changes in the law. I've updated all of my forms, at least for my newer clients after January 1st, to comply with this. What happens if you do not comply? We really do not know yet because the law is so new, and also due to COVID, they're trying to get in front of a court, for a jury, whether it's a bench trial or a jury trial. It can be very difficult at the moment. But I've usually said you should update it. I haven't called all of my clients yet during COVID to say, hey, you should update, during a pandemic. But probably over the winter, I'll most likely call most of my clients and tell them, hey, you should probably update your trust to comply with the current law. Also, to make things a little bit more fun, the federal government decided to give us a change about a month before that, December of 2019. We had the Secure Act. My joke is I think the Secure Act makes me feel anything but secure. But this applies to things like retirement accounts, IRAs, 401ks, 403bs. Previous to this, it said that, okay, well, if you left a beneficiary, perhaps you left your 20-year-old son, your retirement account, when you died, well, your 20-year-old son would probably be able to expand that over his lifetime. However, now that period has been cut down to 10 years. So this made it a little bit less of an incentive. The only plus was, for traditional retirement accounts, you didn't need to take those out until you were 70 and a half before. Now they made it 72. Not a huge honest difference for most people, but the shortening of the time somebody else may need to take it out is a big deal, and that may affect the way you do estate planning as well. Now your spouse can still take it over his or her own lifetime if you leave it to them first, though. So that's something very important that everyone should consider in doing their estate planning. Now, today's the fun part of today's program. You can learn from celebrities, learn about what they did to make sure you don't make the same mistakes. Believe it or not, whatever good or bad you thought about Michael Jackson, he's the only example of somebody that had a good attorney who knew what he or she was doing. Now, Michael Jackson, he was previously married, but he wanted to make sure when he died, his former spouse did not get any of his money. So on the first page of all his wills, trusts, etc., it said, I have intentionally not provided for my ex-spouse so-and-so. She is to be treated as dying before me. Now, I remember when this was on the news, a lot of newscasters read this like, why is this harsh language in there? Read it very solemnly, etc. I guarantee you every estate planning attorney who saw this said, yes, at least this lawyer knew what he or she was doing. Because if he did not include that language, somebody like an ex-wife, a kid you hadn't seen for 20 years, whoever it may be, would be able to probably make a claim against the estate. And oftentimes, if not just creating a huge headache, you oftentimes will have to spend a lot of money to pay them off or on litigation to get rid of them. The old way might have been to say, well, I give my daughter $1. I didn't forget to name her, but I'm just giving her $1. That's really an antiquated way. You need to have it written and more up to date than the way it's written these days. Robin Williams, well, he did a will and a trust, maybe not with a great lawyer, or maybe he just didn't listen to the lawyer, I don't know. But all of the money was supposed to go to his kids when they turned 21. Not a great idea for most people, let alone ones with an estate the size of Robin Williams. He did have a successor trustee, but he only chose one, somebody to take care of his trust when he was dead. Unfortunately, that individual died before he did. So his estate still wound up going through the court system. I usually tell people on these forms you need at least one person, but I always recommend 2 or more. And if you only have one person, maybe it's a friend or a family member, maybe your second choice should be a trust company or a bank or an individual who acts as a professional trustee and or power of attorney for healthcare. Philip Seymour Hoffman. Well, this is where we can talk about estate taxes for a second. Now, most people, or every now and then I get a call and somebody says, well, I'm worried if I don't do any planning, the state will take all of my funds. What about estate taxes? Well, at least today in the state of Illinois, if you have significantly less than $4 million, you do not need to worry. Illinois estate taxes come in at up to 16%, anything above $4 million. And then federal estate taxes kick in around $11.7 million, although that may go down in 2025. It's set to go down automatically to $5 million, assuming the current administration doesn't do anything before that to make it less. So I can only tell you what there is today. But Philip Seymour Hoffman at least had above what the federal estate tax was at the time of his death. I don't think it was $11 million quite at that time. It was probably around 5. And if you were married, assuming your partner outlived you, or perhaps you transferred some of that money to him or her, those numbers could potentially be doubled. And during his life, he gave a lot of money to a lot of good charitable organizations. But because he died unmarried and only with a simple will, no real advanced planning, the major charitable organization that received the majority of his money was the IRS. Michael Crichton, well, this is a library program, famous author. You can take out one of his books, but perhaps he left us with a mystery he did not plan for, because he did a will and a trust, but he didn't update it on his third marriage, and he died with a trust leaving all of the money to a child from a prior marriage. Last I heard, his most recent wife was suing the estate on behalf of their unborn child because she was pregnant with his child when he died. Mickey Rooney. Well, I'm a movie buff. I like to hear about Hollywood stars. But unlike today's stars who are just married, 2, 3, 4 times, Mickey obviously could not get enough of a good thing, because by the time he died, he was on his 8th marriage, but that was the one that really did him in. Now, if you're on your 2nd, 3rd, 4th, 8th marriage, perhaps you don't want to choose your spouse as your trustee, because when she and her adult son became trustee, they managed to imprison Mickey in his own home for a while. He eventually was able to escape, had his day in court where the judge ruled the money needed to go back to him, but he died without ever seeing a penny of his own money back. This can always be an issue. And especially for people who are on second marriages, or people who don't have any children, or people who have children from prior relationships, you want to make sure that you don't leave everything outright to your spouse. And then when your spouse dies, he or she leaves it to his or her own kids, leaving your kids completely out, or your family completely out. You can do planning so that the money can be held, your spouse can receive the income, a separate trustee can determine if they really need this money to live on, or some of the principal needs to be spent on them. But then when that spouse dies, any of the money that's left over will go to your family, your children, etc., or your charities. Prince. Now, Prince was known as being a very smart negotiator for all of his music contracts and videos, movies, etc. But when he died like an idiot. No will, nothing in place, not married, no children. I believe his parents were deceased, but he had some half siblings. But for all intensive legal purposes, a half sibling, even one you've never met, is just the same as if that had been your brother or sister who had grown up with you your entire life. But it's been years since Prince has died. A lot of litigation, a lot of questions, etc. But the only money that's been paid out has been to accountants and lawyers. At least some of the money has gone to a good place. Jim Morrison, well, he was the lead singer for The Doors. He decided he didn't really need an attorney. He could do it himself. And that's exactly what he did. He drafted a will leaving everything to his wife, and they had no kids. About 6 months after he died, his wife died too, without a will. Well, as I said, if you don't have a plan in place, the state has one for you. And when Jim Morrison died, that money went to his wife, so it became hers. And so the next person in line for his wife, because they had no kids, were her parents. Well, her mother was deceased, her father was still alive. So within 6 months of Jim Morrison's death, all of his money went to his father-in-law, not necessarily what he planned. Now, later on, there was some litigation. Jim Morrison's family, I believe, received some of the money, but really this could have been dealt with a lot better with actual planning. Aretha Franklin. I guess for years, her attorneys were trying to get her to do estate planning, a will, a trust, something, but she was a very private person. Now, I've experienced this before. I usually tell people when you come to see me, you need to bring a list of your assets, what they are and what they're worth. And every now and then I get somebody who says, well, I don't really want to tell you that. Well, it's kind of like going to the doctor saying, I refuse to undress, let you examine me, tell you what my ailment is, but help cure me. It's not really a reasonable request. So unfortunately, her attorneys couldn't help her. She died, we thought, without a will, but then later on, there were a couple of wills that she had drafted herself, perhaps not dated, perhaps not witnessed, a lot of litigation, a lot of headaches. A real clear choice of showing why somebody shouldn't do their own will and really should have used the attorneys. And, at some point in your life, you're going to need to trust somebody if you want this to work. Now, Edgar Bergen, he was Candace Bergen's father, or the woman who most famously played the role of Murphy Brown in a TV show years ago. But Edgar Bergen was also very famous in his own time. He was a ventriloquist. He had a ventriloquist dummy or puppet. And this is to show that you don't have to leave any money to your family if you don't want to, but be careful when you do this. Because when he died, he left nothing to Candace. Maybe he figured she had enough money, but he left $10,000 or $20,000 to the preservation of his ventriloquist dummy. Not some idiot that he knew, but basically his puppet. So really, I guess during her lifetime, supposedly Candace Bergen had said that, she didn't get a lot of support from her father, and even in death, her father showed that she wasn't very important. And sometimes people do this with their kids. They say, well, I've got two kids. One is really doing well, and the other one doesn't really have a lot of money. I'll give more everything to the one who's not doing well. Well, before you do this, you might want to talk to your kids, or you may not even want to do that because you may leave somebody feeling very hurt, and you may wind up having kids who don't speak to each other anymore, litigation, etc. So as I said, you can do it, but think about it before you make that decision. It's another thing, if you haven't seen your kids for 20 years and the other one's close to you, that's a different story. Britney Spears. Now she's had multiple mental breakdowns in the state where she's in. That's called the conservatorship. Her father was managing her money for a while, but then I don't know if it was her or her mother or her siblings who didn't want the father managing it anymore. A lot of changes to who should be managing it, etc. But if she would have planned ahead, done powers of attorney before these breakdowns, probably didn't think about it when she was, a young star, but she could have avoided this. And maybe in her case, especially considering the amount of money, maybe it would have been better that she would have just had a third-party trustee managing her money. So that's it for all the stars today, but not quite yet. So I realize we went through a lot of information today. Please don't be overwhelmed. All you need to begin, you need to have an idea of what your assets are and their value, who your beneficiaries are, who do you want to leave your assets to when you die. Maybe you don't know exactly, but maybe at least you wouldn't say, I know I have 5 charities and 2 individuals, whatever it may be, and then contact an estate planning attorney. I will tell you, don't necessarily go to the attorney and say, I need a living revocable trust, or I need this, or I need that. Go to the attorney with an open mind and tell them what you want to accomplish. Do you want the money to go to your kids? Do you care about it going through probate? Is there somebody you don't want to get your money? What are your assets, etc., and let them guide you on what your options are and what might be better options for you. Because sometimes people come to me with a plan because they've done research on their own, and I say, well, maybe you could do that, but I think there's a better way to accomplish the same thing. So now also, before I open it for questions, just a little bit of a note. So there are few things I'll reiterate from before. None of the information you hear today is or should be considered legal advice. If anyone asks me something too personal or something that sounds like legal advice, I will politely just have to, I'll read the question, but I'll refrain from answering it and just say so. The next thing I know I'm gonna get a question about, how much? A, I will never quote anyone over the phone, and B, this is a library. I'm not able to quote, even if I did want to, and my malpractice carrier won't be too pleased with me. The way I generally work, I tell people, you can call me, you can make an appointment with me, you can speak to me for up to an hour. At the end, they'll say, based on what you have, based on what you want to do, this is what I recommend. This might be another option or two that's not as preferred, but may still accomplish some or all of your goals in one way or another. If you want to hire me, it's half upfront and half once completed. If you don't use me, I don't charge for the consult, assuming it's an hour or less. So that's really as fair as I can be, and that's all I will speak on about price today. And the best way is to really call me. People do email me, but very difficult to sometimes tell the person what I need and to set up an actual appointment. Phone call is much easier. My phone number is at the top of the screen on your slides, or should be on the handout that you received. If you did not receive your handout, please either email the library. You can email me if you just need the handout as well. So without further ado, I will see if I've got anything in the Q&A. I encourage everyone to ask questions. This will be the last time you get to speak to a lawyer for free.
And there are no questions. I can't believe there are no questions.
That's a first for me.
Yeah,
looks like we've got one.
Okay.
Spoke too soon.
Are you taking actual in-person appointments?
So yes, I am taking actual in-person appointments. I tell people you need to wear a mask, bring a driver's license or a state ID with you because I cannot see your face. I've got an air purifier, and hopefully next week I'll be getting my second shot. So.
Oh, congratulations.
Thank you.
What should orphan seniors do?
I don't know what they mean by orphan seniors. So somebody who doesn't have any friends. Oh, okay. Friends or family if there's no one to inherit. Well, if somebody has been orphaned, then you should think about who your beneficiaries are. If you can't think about beneficiaries, at very least you should have powers of attorney for healthcare and property. But if you have no will or irrevocable, or if you have no will or trust that leaves it to anything, that means when you die, all of that money is going to sit basically and go to the Illinois Treasurer, where it's going to sit indefinitely. So I'd encourage people, if you don't have any friends or close family, think about a charitable organization that might do you some good. It might be your alumni association, it might be your house of worship, your church, your synagogue, your mosque, whatever. It may wind up being your local library. A lot of suburban libraries do have a charitable arm, maybe a Friends of the library, might be your animal rescue. So there are a lot of worthy places, much better than having it just go and sit at the Illinois Treasurer's website, etc. So let me see. Can an irrevocable trust take out a loan?
To purchase real estate.
Sorry?
Yeah, there's two parts of that. To take out a loan to purchase real estate.
Loan to purchase real estate. The answer is I'd probably have to see the trust. I don't know what that one. I mean, a revocable living trust definitely can be used for that. Well, I shouldn't even say that. When the person is still alive, because obviously they could change it, they could change the language to allow for that if it's not already in there. An irrevocable trust, it depends. I don't know what the purpose was. I'd have to look at the exact document. How do you choose an executor? Choose somebody that you think is honest, can deal with money, and ideally somebody who is significantly younger than you, for the reason that obviously as you're getting older, that person's getting older too. Or if you don't have somebody, as I said, there are organizations that you can have. And usually, aside from the healthcare one, like to make your healthcare decisions, if you're only talking financial decisions, they usually are not going to charge until your permanent disability or death. It's not like they start charging today, at least if you're using a living revocable trust, they take over upon your death, disability, or if you resign. So really a good choice for somebody who doesn't. And I have a lot of people who honestly don't really have somebody or don't have somebody that they trust to make these decisions for them. That's completely fine, but I work with that issue all the time.
Okay, so anything else, you guys?
Let's see. Anything else?
Anything in chat?
Okay. I think that's all we've got, unless you've got any, Penny.
No, I will say though that the last time I heard you talk, I went and got my healthcare power of attorney updated. So thank you.
Okay. welcome.
And
Now let's
here's
see.
something
Can
else.
an LLC be owned by an irrevocable trust? Yet again, I'm not sure why I'm getting all of these irrevocable trusts, but yes, ownership is not reflected by revocable or irrevocable. Most of mine are generally revocable trust, although they obviously do become irrevocable when the person dies. An LLC, it's just another asset, but it has to be properly registered with the Secretary of State for that.
All right.
Okay, and then I got something else.
Good presentation. Thank you. Again, I hope that everybody who's here got their handout. If you didn't and you still want it, please, like Jacob said, either let him know or let the library know. We'll make copies and have them available for you. Thank you for coming.
Okay, hold on. Looks like thank you so much, Jose. One more. If you are interested in Medicaid, does living revocable trust protect you from the state recovery? Absolutely not. Living revocable trusts are usually for probate and guardianship avoidance. You might use it for estate taxes. The way you can generally apply for Medicaid, although this is beyond my area of expertise, this is elder law. Essentially, you have to give up all of your money to somebody else, meaning you don't control it. The money is not yours 5 years prior to applying for Medicaid. A little bit more complicated than that, but most people don't generally like it. This is usually to preserve money. It might be for a spouse, but usually it's for the children. And this can be unfortunately difficult. I usually encourage people, if you want to plan ahead for something like that, consider long-term care insurance, at least ideally when you're younger, because oftentimes what happens is people want it, they're 70, 80, 90, and it's too expensive or they don't qualify. And when you're 40 and 50, you don't think about it. But for people who are younger, definitely think about long-term care insurance. I don't sell it, I'm not an insurance agent, but you can speak to somebody else on that as far as, as far as that is concerned. If you don't mention a relative, can they make a claim on your estate like a sibling? Yes, that's exactly what I was stating before. It's whoever your most recent heirs are. So usually for me, I have a section called My Family. It may say I'm married, not married, have kids, don't have kids. It depends. If you're married and you have kids, chances are of your sister making a claim or your sibling making a claim pretty low because there are people in line before them. But if you really want to make sure there's somebody who doesn't get any money, you can write them out. It doesn't prohibit them from making a claim. Anyone can make a claim. I can make a claim on somebody's estate, but if I've got no standing, no purpose to make the claim, I'm not next in line, it's going to be dealt with pretty quickly. It's going to go away. So yeah, but you need to write that quickly. Some people, the problem is you don't mention your sibling at all, and usually what happens is it may go down to your heirs, or that person, especially if you go through a probate estate, that person's actually going to receive notice that you died if that person is your heir. And there's actually even going to be a form sent to them that says you've got the right to make a claim. So if you don't do it and do it right, prepare to have your estate going to that sibling that you don't like. So, okay, if that's all for today, thank you, everyone. I hope you enjoyed today's program. For anyone who needs to see it again, is it also being recorded and kept as a recording?
It was recorded live on Facebook, so it should be on the library Facebook page if you would want to look at it again. Yeah, sure. Absolutely.
And for anyone who wants to see future programs, my website does list other programs that I'll be having. If anyone needs to see a live one and they couldn't make it today or they missed out on part of it.
Great. Thank you, Jacob.
Okay, thank you, Penny. Thank you, everyone. And thank you to the library for letting me host this, and to you and the gentleman who was on here before who helped, I assume, set up Chris. Some of the IT work.
Yes, absolutely. All right, I'm going to close you out. Thank you so much.
Okay, thank you. Bye.